But back in 1882, the Supreme Court first looked at this issue. And the question was, here we go, famous photograph of Oscar Wilde. And the question was, could this be protected by copyright? The defendant argued that the work was created by a machine, a camera, and it was done upon the click of a shutter, and it was all mechanical. And so the question was, could this be the subject of copyright? And the Supreme Court said yes, the photo could be protected because there was human authorship in the photographer's choice of the setting and the pose and the lighting and the costuming and other creative elements. And so that began more than 100 years of discussion of this issue. In the 1960s, the Copyright Office started looking at similar questions dealing with works created by a computer. And the Register in the 1960s explained that the crucial question was whether the work is basically one of human authorship with the computer merely being an assisting instrument, or whether the traditional elements of authorship were actually conceived and executed not by man, but by a machine. And in the 1970s, you had the National Commission on New Technological Uses of Copyrighted Works, or CONTU, coming to a similar conclusion that US copyright law excluded protection of non-human creations. And now this issue is becoming more pressing. Every week, I see new press reports about the miracles that can be created by computers. We have AI systems that can produce works of art and poetry and other works that often are so creative that they can't be distinguished from human creations and are even winning awards. And so the issue has come before the Copyright Office. There's two major issues involving copyright and AI, at least to date. And one has to do with authorship, and the other has to do with the ingestion of copyrighted works for machine learning. So if we start with authorship, let's take a look at the image in the next slide. So in 2018, Stephen Thaler filed an application to register a copyright in this work, A Recent Entrance to Paradise. And the author was cited in the application as the creativity machine, with Thaler listed as the claimant and owner. And when we got this application, I mean, first of all, if you look at the image, it is quite attractive and I would say quite creative. But the examiner declined to register it because there's no human authorship based on the facts as cited in the application itself. And so Thaler appealed to the office's review board, and he made three arguments for why the work should be registered. First, he argued that there was no binding authority prohibiting the registration of AI-generated works. Second, that we already register works to non-human entities, to corporations, under the work made for hire doctrine. And third, he said it would be good policy to register AI-generated works. Now, the review board upheld the denial of the examiner based on the text of the Copyright Act and the term works of authorship and how courts have interpreted those terms. The board in particular cited a couple of cases dealing with, well, the famous case dealing with the monkey selfie, a photo taken by a monkey, and also an application to register a text that was purportedly written by divine spirits. And citing these sources, the review board said no, that the work was ineligible for copyright protection because the applicant had indicated that no human was involved in the creation, so it was not the work of a human author. And on the second argument about the fact that the office already registers works to non-human authors, the review board pointed out that work for hire status under US law requires a contract, either an employment contract or a separate contract between an independent contractor and the hiring party. And of course, a computer can't enter into a contract. And in any event, even if it could, the work for hire doctrine wouldn't help because it identifies the owner of a copyrighted work. But if there's no human author, there's no copyrighted work to be owned by anyone. And finally, on the policy front, Thaler said that, look, if the office refuses to register AI-generated works, this will invite applicants to lie, essentially, to falsely claim authorship of works that in fact were created by a computer. And the review board rejected this argument because, in fact, fraudulent applications are not unique to the AI context, and there are already penalties in place to deter fraud on the office. I will note that we have recently seen reports on social media and in news outlets of people claiming that we've registered a work that was in fact created by AI. And all I will say, while I can't comment on specific claims, is that if we're aware that a work was created solely by AI, we will not register it. So after the review board rejected the appeal, Thaler filed a lawsuit in June in federal court, and that lawsuit, Thaler versus Perlmutter, is ongoing. So I would just make the point that this case addresses only the clearest and simplest AI authorship issue, because the application specifically stated that the work was autonomously created by a computer algorithm and did not involve any creative human effort. And similar cases have been brought by the same applicant involving patents and inventorship before the Patent and Trademark Office, as well as offices in other countries. And the result in the PTO was the same, a rejection of the application. Now, why is Thaler saying there's no human involvement? Really because these are all brought as test cases to test the boundaries of the law. But there are going to be many other cases where humans are more involved in works produced by AI. At the other end of the spectrum from this one, you could imagine a situation where a human takes a photograph, uses AI in post-processing to clean up the image. And then somewhere in the middle, you could have a human giving AI a simple text prompt, and the AI writes a poem, and then the human edits the poem. So the ultimate question is always going to be, at what point does the human involvement cross the threshold into authorship? Now, the next slide is an example of a more difficult question. So in March, the Canadian IP Office registered copyright in a painting called Surrealist, and that's the one on the right here, that was created at least in part by AI. So here's how this was created. A human being selected two images as inputs for the algorithm, and there's a style image, which was Van Gogh's The Starry Night on the left, and a content image, which is the photograph of the sunset in the middle. And the AI produced a version of the photograph with the style of The Starry Night, and that's what you have on the right, Surrealist. Now, when there was an attempt to register this work here, we rejected the application because we couldn't identify the human contribution to the final work. The author of the photograph was a human, but the registration application was for a derivative work, and it's not clear that there was any human contribution in the production of the derivative work as opposed to the underlying photograph. So you can see already that there are differing results being achieved in different countries, looking at the more complicated issues where a human has some involvement in the production of the work. Now, I will say, in many ways, the more difficult and arguably more immediately important issue is the use of copyrighted works as input for AI. And of course, training an AI requires supplying it with massive amounts of data. And in many cases, that data will include, many cases, if not most cases, that data will include material protected by copyright. Now, in the United States, most AI researchers will rely on the fair use doctrine. And the leading fair use case looking at mass ingestion of copyrighted works was Authors Guild versus Google. And that involved the scanning and copying of works books into a searchable database. Now, the Second Circuit Court of Appeals found that to be fair use, but I think it's worth pointing out that the court found it particularly significant that Google's digitization and search engine made it possible to text and data mine millions of books to discover the frequency of word and phrase usage over time. And one of the key facts for the court was that the texts themselves were not being made available to the public. So I raise that distinction because we held an event on machine learning last year and heard from a number of artists and scientists who've trained AI programs to create paintings and music. And that included the Obvious Art Collective and OpenAI, which has launched products like GPT-3, the Jukebox algorithmic music generator, and the DALL-E text-to-image transformer. And we also heard from a number of scholars and lawyers. And one of the questions that participants raised was exactly this, whether courts would treat differently the two different types of uses, and that is the ingestion of copyrighted works for expressive purposes versus non-expressive purposes. So on the one hand, you have the purpose of analysis to shed light on the information contained in the works. And on the other hand, you have the purpose of creating new works to make available to the public. So you can imagine feeding into a computer all of the works of the Beatles and other artists so that the AI can help identify trends in Western popular music from 1960 to the present. And if the output is a trend line or a table in a research paper, that seems quite transformative and unlikely to harm the original works in the marketplace. On the other hand, if you feed into an AI, into the computer, all of the works of Taylor Swift so that it can learn to create music in her style to compete in the market with her songs, that seems quite different. But what if the output is not substantially similar to any particular Taylor Swift song, but could nevertheless substitute in the marketplace for her songs? And that could impact the fourth factor of the fair use analysis, the impact on the market for the copyrighted work. So there are a lot of open questions here. Technology is moving very fast, and AI art is becoming more and more impressive every day. And the ultimate question at the end of the day, I mean, I expect we're going to start seeing a lot of litigation in this area, but the ultimate question is going to be, how should the law treat these situations? Are IP rights either necessary or desirable for this type of output? Would it lead to more or better works being available to the public? And are there sufficient incentives without separate IP protection for the machine-generated content? What would the effect be on human creators if we provide this type of protection? Will huge volumes of AI-created works diminish the market for human works to the extent that they displace them in the market? Will human authors still be able to make a living? And then on the ingestion side, if fair use does apply, should we look at any kinds of changes to the law? If the law, if we have a situation where the law does not prevent the feeding of all of these copyrighted works into the computer, should there be any form of credit or remuneration for creators who have made possible this new output? So we have all of these questions on our minds. We will see where the courts go with this. We are examining the issues, looking at them, discussing with counterparts abroad as well as with stakeholders in the United States what the various approaches are that we'll develop. And I will stop here, and I'm happy to take any questions. And Rob is here as well, especially for questions related to registration.